I'm sure everybody here is familiar with the landmark Schrems II judgment of the CJEU from July 2020. What the EDPB did is that it carefully studied this decision and issued in particular some recommendations on supplementary measures which have to be put in place where the assessment of the specific circumstances of a transfer would not ensure an essentially equivalent level of protection as the one provided in the EU. Concerning the complaints raised by Neub, in August 2020, a few weeks after the Schrems II ruling of the court, the association None of Your Business, which you all know, I'm sure, of Maximilian Schrems, addressed 101 complaints to all 27 DPAs, as well as to the 3 EEA DPAs, which are also members of the European Data Protection Board. These complaints concern transfers of personal data of website visitors collected through Google Analytics and Facebook Connect tools to measure the audience of these websites. Indeed, Google Analytics provides statistics on website traffic. These complaints concerned clients of Google Analytics since they were directed at website owners using the service. Therefore, as Gwendal mentioned it was decided to set up a task force within the EDPB to coordinate the analysis and handling of the complaints. This work resulted so far in one decision adopted by the Austrian DPA, 3 orders to comply issued by the CNIL, and one very recent decision adopted by the Italian Garanti. The EDPS also issued a decision on the same subject at the beginning of the year. What I would like to stress is that the position held by the CNIL in these complaints, in these orders, is therefore not an isolated position. It was carefully discussed and assessed within this task force. Also, the decision issued by the CNIL, in addition to the discussions within the task force, were submitted to the one-stop-shop mechanism of cooperation provided by the GDPR. They were therefore also agreed by the other concerned supervisory authorities in the different cases. Other decisions should also be issued by other DPAs in the near future, and these decisions on substance and on their form result from a collective work of all the EEA and EU DPAs. Given the positions of Google Analytics and Facebook Connect tools on the market, these are indeed strategic cases. Google, for instance, holds 80% of the market, so that represents a lot of European users, as you can imagine. So what were these complaints about? Google Analytics is a service that can be integrated by websites, such as online sales sites, in order to measure the number of visits by internet users. In this context, a unique identifier is assigned to each visitor, and this identifier actually constitutes a personal data, as well as the associated data, which are then transferred by Google to the United States. The CNIL, in cooperation with its European counterparts, analyzed the conditions under which data collected through the use of Google Analytics was transferred to the US and the consequences incurred for the individuals concerned. The aim was to collectively draw the consequences of the Schrems II judgment. In these cases, Google, as a communication of electronic service provider, falls within the scope of the problematic US legislation assessed by the European Court of Justice in its Schrems II ruling. It can thus receive access requests from national security authorities. In this regard, the sensitivity of the data is actually not a criteria that was taken on board by the court, and therefore it applies to all personal data transferred. In accordance with the EDPB recommendations which I mentioned concerning supplementary measures for transfers, the CNIL and its counterparts found that although Google has adopted additional measures to regulate data transfers in the context of the Google Analytics functionality, these are not sufficient to exclude the accessibility of this data for US intelligence services. The technical measures, in particular, we talked about encryption this morning, were insufficient to ensure that only safely encrypted data were transferred. This means that encrypted by a third party than Google itself. Other additional measures closer to commitments of good practice, for instance, the commitment to bring actions against illegal access requests, are by definition insufficient, since what is problematic for the CJEU are actually not the illegal requests, but the legal ones. So this is not enough. There is therefore a possibility for French and other EU website users who use this service and whose data is exported that these data could be accessed by US public authorities, and the website owners, as controllers, cannot be exonerated of their responsibility when their processors have not put in place the necessary safeguards. The CNIL therefore ordered the website manager to bring this processing into compliance with the GDPR within 1 month, if necessary by ceasing to use the Google Analytics functionality under the current conditions, or by using an additional tool that does not involve a transfer outside the EU.